My Lords, a couple of points that arose before the short adjournment, and I can just tidy them up for your notes. I was asked where the issues of coexistence agreements arose. My Lord Justice Baker pointed out some of the paragraphs. There's a couple of other references. It's paragraphs 76.
So this is in the judgment, yeah?
Yes, my Lord.
Yes, 76, oh yes.
To 82.
Yeah.
But also pertinently,
That's just a summary of the law, isn't it? Of the Omega decision. He doesn't make any...
Oh, well, he does.
Does he apply it to the facts of this case?
He says that my submissions are wrong. That's the second sentence of 77.
Yes, well, you remember that.
And also, my Lords, if you go to paragraph 317, this is page 134 of the judgment, he says, what I have not relied upon, and he does not list there the coexistence agreements. So I realise it's an inference of the negative, but those are the references anyway for my Lordship's notes.
And doesn't rely on the code.
And I was also asked where the judge dealt with Greenwich.
Yeah.
And pertinently, that's just for the first lot of references, so it's paragraphs 74 to 75, page 87 of the judgment.
Thank you.
And that basically deals with the questions that arose before the short adjournment.
Thank you.
I'm going to deal with, if I may, the second ground of appeal. This is conditional in the way in which I explained it.
Yes.
I was going to take this really incredibly shortly because the judge only dealt with it in one paragraph, paragraph 313, which is on page 134 of the judgment, at the top of the page. 3 lines, 2.5 actually. And the law is pretty settled in this matter. The relevant references are given in the skeletons. And the long and the short of it...
Well, although you have put an additional authority on that subject in the bundle, which is Swatch and Samsung, which isn't cited in the skeletons.
Yes, but that's...
And what you have not done, even in the bundle, is to put, in fact, the most recent decision of this court in, which is Iconics and Dream Pairs.
Yes.
And that's a prompt for me to ask you a question, because I'm struggling at the moment to understand how post-sale confusion makes any difference from your perspective.
Right.
As a case like Iconics illustrates, where it can be particularly relevant is where you're concerned with device marks, and there's an argument that at the point of sale, there's no likelihood of confusion because this device, the trademark goods are sold together with statements which unambiguously show that the origin of the goods is not the trademark proprietor. And then the goods bearing the device then go out into the market unaccompanied by those statements, and at that point you have a likelihood of confusion. And that was the conclusion of this court in that case. But how does this operate? Because here, the sign with which we are concerned, just as the trademark, includes both device and words. And the defendants aren't relying upon any accompanying statements at point of sale as negative likelihood of confusion. Their case is it's inherent in the sign. So how does post-sale confusion make any difference?
There's 2 points my Lord has made. The first of which is the most recent case, Iconics. Is the only reference is in paragraph 12, and that relates back to paragraph 85 of Samsung, which sets it all out. So there was no need, in my view, to include that because it basically referred back. And the paragraph 85...
But it's an illustration of why it can make a difference.
Yes, my Lord. I accept that point. but with respect to the law, that's why it wasn't included.
Yeah.
And for your lordship's note, paragraph 85 of Samsung is in the authorities bundle, tab 17, so that's bundle C, and the relevant paragraphs
For my Lord's benefit, it might be worth
882.
looking at that quickly.
Fine.
I've just caught up on what the Lord said in Iconics. I found that online. But that's...
There was confusion post-sale, because when you're looking at the relevant sign on the shoe of the wearer, that makes the relevant sign more similar to the alleged trademark. Sorry, the allegedly infringed trademark.
Okay, right. Where is Samsung?
Samsung is authorities bundle C, tab 17.
No.
And it's paragraph 85, which may
Well,
be
you
found.
need to read 84 as well,
Yes.
because otherwise the first sentence
Sorry.
doesn't make any sense.
Sorry.
When you get to 85.
For these reasons, yes.
Sorry.
Okay. So 84.
Page 881, 84, 85.
This is you, is it? Well, I'm glad I read that paragraph. It's a very...
And
84. Now 85.
my lord, yes, that basically just gives you all the case law reference.
Yeah.
The fullest exposition is in data card.
Well, do we need to go there?
No, in my submission you don't.
I've
But
got
if
the
you-
point.
If you do want to read all the background, you can see it's fuller by the number of paragraphs that are quoted, 277 to 289 of that case. And that sets out pretty much everything you need to know about this particular
Yeah.
topic.
I will read that.
That's the first point that my Lord Justice Arnold raised, which is why I didn't put Iconics in. And the second point is on the facts. We say things like, what the judge was saying at first instance was that in certain cases, there were, when you're looking at a physical shop and buying some of the goods, there will be, on some occasions, but not necessarily all, and we say not sufficiently all, occasions when there are other polo-themed branded t-shirts and polo shirts out there that are on next door adjacent shelves and
Hangers.
hangers and what have you. And that therefore in a shop you may see these other third-party side-on logos. And that's how the at-sale confusion assessment might be different from a post-sale assessment of infringement, because you wouldn't see necessarily those adjacent items for sale. That's really all I have to say on that. But you can see what I'm trying to say is that there are differences in the factual matrix, and that is a particular example. And that was not taken into account, as you saw in paragraph 313 of the judgment. I really wasn't going to say much more about that because it is a conditional point and it is really very narrow on the facts.
Thank you.
But I just wanted to make clear one point. When I was asked by my Lord Justice Arnold about whether or not I accepted the proposition that marks with a lesser distinctive character are thereby entitled to a lesser degree of protection? The answer to that is clearly yes. My Lord followed that up by saying, I was relying upon an old case. Yes. We had not found any newer case when we prepared the skeleton. That was last year, the end of last year, 2023. But the point about that is if there's been any more recent case, it would only be persuasive, not binding upon your lordships, again because of the withdrawal agreement. And we're not aware of any in any event. So that sort of diminishes the fact that we haven't found anything, you see what I mean. But what we have put before you is what we think is the relevant law. We hadn't found anything that said that that was wrong, so to speak. So that's as far as I can take that. And in contrast, in case there's any ambiguity, even though marks with a lesser degree of distinctive character are entitled to a lesser scope of protection, we say that you can't artificially reduce that distinctive character because of certain factors. The allegedly infringing activity of a defendant shouldn't be taken into account because the wrongdoer can't benefit. Same likewise with third parties and the AG's opinion to that effect. And then the other way of looking at it is that you should only take into account the local context. And the third way of looking at it is, in any event, in this case, you don't have the correct factual matrix to say that there is no significant cohort of people who are unaware. And therefore you have to judge the issue of the existence of likelihood of confusion by those for whom the mark is the most distinctive. My lords, might I just check? My lords.
Thank you very much, Mr. We may or may not hear from Edinburgh. Sorry, we may or may not hear from Mr. St Quentin in due course.
Yes, exactly so.
Let's see how we go.
My lord, thank you.
Mr. Silverleaf.
Lord, thank you. I'm going to take it slightly backwards, if I may, because I think I can deal with post-sale confusion in about 45 seconds. There's not a shred of evidence to support the suggestion that my own friend has just made. There's any difference between the sale environment and the post-sale environment. The marks are complete and entire, they're embroidered on goods, they're on the neckbands, they're on the swing tickets. If you see the goods out in the wild, as it were, you will see the mark as a whole. It's exactly the same cause of confusion, alleged cause of confusion. Secondly, the primary evidence of confusion, and I would suggest that you read the section of the judgment from 220 to 253 with some care, dealing with the essentially, substantially total lack of evidence of any relevant confusion at all between the parties' respective goods, where they have been on the market for decades, side by side, in the same shopping mall. They are sold through dedicated outlets. Each party has at least one shop in the mall, and those shops are branded with the parties' logos and can sell only goods branded with those logos. The point, they found no confusion at all. They were unable to establish any confusion in those circumstances. They can't establish confusion in those circumstances. The proposition that the post-sale environment makes a difference is devoid of substance. Now, the next thing, I will confess, I was slightly surprised by the way my learned friend has advanced his case, because it's not what I was expecting from this skeleton argument. Proposition that there is some bright line distinction in comparing my mark with his mark, my sign with his mark, as compared with the other goods on the market, like Ralph Lauren and US Polo, is completely and utterly in conflict with the case they have advanced against alleged infringers or in opposition. In this particular case, they sued on all the signs we have used. And my learned friend focuses on sign 3, which is in his skeleton. What he hasn't focused on is signs 1 and 4, which you'll find in the core bundle at tab 6, page 73. which contain the graphic that my clients used to use before they entered into an arrangement with Ralph Lauren, which is, if I may say so, quite similar to the Ralph Lauren logo, which you'll see at page 110. And you see it at page 110, both as it sometimes appears with Polo Ralph Lauren underneath it. Sometimes it says Polo by Ralph Lauren. It also appears very frequently in the form you see it on the t-shirt below. And in that large logo form, as well as, I suspect I don't even need to tell you this because you will have seen them in the street, small logos of the same form. That logo, that Ralph Lauren logo, I'm not wearing my lucky Ralph Lauren socks.
Yeah, you're assuming, you say we see them in the street, you're assuming none of us have got one. So.
Well,
I'm not at liberty, I haven't, but I don't know.
No, I was going to wear my lucky Ralph Lauren socks, which have a little logo on each ankle, but I forgot to put them on this morning.
Well, lucky so far.
But the point is, the Ralph Lauren logo is used all over the world in enormous quantities. It must be recognised by virtually the entire brand-aware public. If it isn't, I'll be surprised. It's not just against me that they complain about logos that look nothing like the distinction my own friend sought to make between the forwards and sideways. First of all, the Ralph Lauren logo isn't forwards, it's a three-quarter view, just like my sign 1. Secondly, when you look at what they complained about in the Greenwich action, he took you to page 713 of the authorities. He didn't take you to pages 719 and 720, which is volume 2, isn't it? No, no, it's volume 3. No, volume
No, it's
2.
2. And there's 2.
Oh. I'm sorry, I've got completely the wrong thing. I apologise. 719 shows you what the rest of them look like.
The sign is on 720 in my case. Right.
I seem to have a completely different bundle set from here. Mine is in volume C.
It's tab 13.
Yes, my tab 13 is in the 3rd volume, unhelpfully.
So what are you asking us to compare?
I need to turn over to 720 and you'll see they complain about 2 horses coming straight ahead, 3rd one down, Greenwich sign 3, 2 horses running sideways. Basically, the 2 horses running straight ahead are just like the US Polo. They complain about that, even though it's got the Greenwich Polo Club name plastered all over it. They tolerate, from Santa Barbara, if you go to the supplementary bundle, tab 5B, page 191, that sign. The distinction my learned friend is trying to make is completely at odds with the evidence in this case. So there's no evidence of confusion, even where the parties' goods are on the market side by side. The next point is that they argue that there is jurisprudence which supports their argument that the state of the market is irrelevant for the distinctive character of a trademark. When I come to the authorities, I shall show you that each of the authorities relied upon by the appellants is addressed to a different point than the one before this court, and it follows the appellant's endeavour to read them onto the circumstances of the present case are flawed and should be rejected. In particular, cases considering whether prima facie infringing use, that is, use of a confusing sign, does not cause confusion because of something done by the defendant in conjunction with the infringing use, are not relevant to the question which arises in this present case, which is whether the mark and sign are confusingly similar in the first place. In other words, the extent of distinctiveness of the sign and therefore the extent of protection to which it should be entitled. The two questions are utterly and entirely different. The first one starts from the assumption that the mark and sign are confusingly similar, and the defendant seeks to advance a defence that despite that, I'm doing something that eliminates any actual confusion. Answer, that's not relevant, because a trademark gives you protection against the use of a confusingly similar sign. But that tells you nothing about the question to what extent, when you're assessing whether or not initially the mark and the allegedly infringing sign are to be considered to be confusingly similar at all. A conclusion which the trial judge in this case has rejected. What the public perceives and expects is irrelevant. And that a proposition that that is the case is, if I may respectfully say so, contrary to common sense. It is the public's expectation, the average consumer's expectations, that govern whether or not similarity, confusing similarity, should be found. Now, an underlying point that I would ask the court to bear in mind throughout the argument is that trademark cases are by their nature highly fact-specific. Jurisprudence needs to be read with that thought firmly in one's consciousness. A particular aspect of this is that the analysis may be significantly different when one is looking at a unitary mark, that is a mark with a single element, either a word or a figurative element, a picture, rather than a mark which is a composite mark, where the individual components, one which includes words and pictures, for example, where the individual components of the mark may make different impacts on the consumer's mind. The distinction is especially significant where a mark has both verbal and figurative elements. The verbal element will often be the mental mechanism by which a mark is primarily recognised. As your lordships will, I'm sure, already have appreciated, these considerations are central to the present case. My learned friend opened the entire appeal without reference to the fact that his mark is a composite mark, which includes not only the picture, but the name, which is the primary identifying material. And until Lord Justice Baker asked him, are you going to say anything about it, he was silent. He was operating on the basis that you just look at the pictures. That, with the greatest possible respect, is completely illegitimate. The average consumer, as a matter of law and as a matter of common sense and fact, will look at a mark as a whole. And in a mark which includes both words and pictures, it is trite law that it is likely to be the words that are the key on which the consumer hangs that box. Turning to the key issue, the opening of my note says the following, which is, Lord Justice Arnold may consider plagiarism. It is trite law that marks with a greater degree of distinctive character should be given a larger penumbra of protection. It follows axiomatically that marks with a lesser degree of distinctiveness should be given a smaller penumbra of protection. Indeed, the two statements are saying the same thing, looked at from opposite directions. You can't have a comparative level of distinctiveness unless you allow for lesser as well as greater. It's a nonsense. And there's no sort of bar at the bottom where you have a sort of, I don't know, what was I going to call it, a medium distinctiveness, and you can't go below that. It's a property of a mark. Distinctiveness is a property of a mark which may be inherent. Does it look and feel to the public like an indicator of trade origin, such as an invented word or a surname identifying the maker, or acquired by use through education of the public that it indicates a particular source? Whilst there are different origins of distinctiveness, the resultant property of distinctiveness in the public perception is qualitatively the same. It is the ability of a mark to distinguish in the public mind the goods or services of one trader from those of another. Its ability to indicate trade origin as opposed to something else about those goods or services. This court has said more than once, and the classic statement is in paragraph 123 of Lord Justice Kitchen's judgment in Interflorence, Marks and Spencer, that the distinctiveness of a mark is intimately tied to the scope of protection to which it is entitled. That must be so, whether the distinctiveness is inherent or acquired. There is no rationale for treating inherent and acquired distinctiveness differently when addressing the question of infringement. Accordingly, in our submission, the distinctiveness of a mark should be taken into account by the court in the assessment of infringement in the same way whether it is inherent or acquired. To do otherwise would be contrary to both reality and common sense. It is nevertheless clear from the appellant skeleton in paragraphs 14 and 15, the appellant's argument on this appeal is expressly and avowedly based on the converse proposition that when considering whether two marks are confusingly similar, it is right to take into account enhanced distinctiveness of a registered mark from its recognition by the public, but to ignore diminished distinctiveness arising from the recognition of the public of what is in the marketplace. This is said by the appellants to follow from the CJU rulings you've been shown, which the appellants argue make it clear that diminished distinctiveness is irrelevant unless it satisfies two conditions. One, that what is present in the marketplace infringes the registration, and two, that the infringement has not been policed with the result the effect of the competing marks has been to destroy the distinctiveness of the registered mark so that it should be removed from the register. The appellants are wrong in my submission in both principle and practice. Moreover, the appellant's proposition is one which is contrary to common sense. If enhanced distinctiveness is relevant to the scope of protection to which a registered mark is entitled, then logically the same should be true where a mark has reduced distinctiveness by reason of market conditions. If a distinctiveness of a mark is relevant to the scope of protection to which it is entitled, then that should be so, whether the distinctiveness is more or less than one would conclude based solely upon the inherent properties of the registered mark. Consequently, in our respectful submission, the proposition being advanced by the appellants is one which should be approached with caution. As with all propositions which are inherently unlikely to be true, it needs clear and persuasive support before it should be adopted. Now, coming back to the source of English law that I've just mentioned, Lord Justice Kitchen in Interflora at paragraph 123, that is in volume
1 and 2, starting 2.
Tab 8.
The first authority is the second one.
Right. Mine are completely differently bundled.
Well.
Which makes life. It's at tab
8.
8, page 456. Just before dealing with that, the whole of the section on the average consumer, which starts at 450 and runs through to 459, I think, no, even further, runs through to paragraph 130 at the bottom of page 459. I'm not proposing to ask you to go through it, but my submission, particularly because at least one member of the court will be intimately familiar with it,
Yes.
is that it is all extremely informative. At 1, 2, 3, the particular proposition that I want to get at, important to have in mind that the issue of trademarks distinctiveness is intimately tied to the scope of protection to which it is entitled. And he then goes on immediately to say, for example, it is well established. So he recognises, rightly in my submission, that the one direction he's about to set out, namely enhanced distinctiveness, is to be taken into account, and therefore that's why you look at the end of the paragraph at the consumers of regard to the impact of the accused sign on the proportion of consumers to whom the trademark is particularly distinctive in that circumstance. He's quite clear, and in my respectful submission, entirely correctly clear, that direction of travel is an example. My Lord Justice Arnold is quite right that, astonishingly, the reverse direction of travel just doesn't seem to feature in the cases. And I suspect the answer to that is this. Normally, when you're looking at the level of distinctiveness, what you're looking at is whether a particular component of or a mark as a whole is descriptive as well as distinctive. The more descriptive it is, the less its inherent distinctiveness, the more you have to have acquired distinctiveness to make it have a broader scope of protection. Therefore, the issue tends to be discussed in terms of descriptiveness against distinctiveness, rather than lesser or greater distinctiveness. But the principle applies with full force and effect to marks and components of marks, which are common in the trade because there are common themes. And this case is a perfect example. Polo-themed branding is very popular. It sells well. And I'm about to show you in the judgment where the judge quotes exactly where the claimants, the appellants, come from on this topic. What the manufacturers and vendors of these products are trying to do is to associate their goods with the cachet of the sport of kings. And therefore, there will be elements of their branding, the primary purpose and effect of which is to evoke the sport and spirit of polo. The brand origin significance has to be looked for elsewhere. And in this particular case, it's the names attached by the parties to their goods. That is the primary indicator of origin. There is one exception to that rule in this circumstance. The originator of the idea of branding goods with polo theme, Ralph Lauren. Ralph Lauren started decades ago, is a huge player in the market, billions of pounds worth of sales across the world. And it alone is able to rely on its iconic image, the picture. I know I'm not the average consumer, but because I'm obviously sensitised by my knowledge of this case. But I was catching a train the other day, and there was a man walking towards me wearing a gilet with a big Ralph Lauren logo on the left breast. There's no doubt that...
Well, we've all now been sensitised, so the whole of the summer we'll be watching.
And then you realise that actually, day after day you walk past people in the street wearing these logos. They're very common. If you watch any sports players, they're all wearing logoed clothing. Usually the logo of the manufacturer is on the left breast, sometimes on the right. But it's an incredibly common thing to do. And these parties use their names and pictures, and as do many others. And what you deduce from this is that the public must be acclimatised to this material and must therefore use the name as the primary distinctor to enable them to determine the origin of the goods as opposed to the theme. And the picture evokes the theme. And if I could take you to, sorry, let me pick up my note. If you go to the judgment in the core bundle at tab 6 and go to paragraph 92, my note says paragraph 92 at page 92, which seems to me be inherently unlikely.
No, it's right.
But it is actually right.
Can I ask you, Mr. Silverleaf,
Yes, of course.
apropos of nothing, why the left breast and not the right breast?
I haven't a clue. I will endeavour to find out from those in the faction.
Well, isn't that where badges are normally?
It's where medals are.
Medals.
Probably
and-
comes from something like that. It's probably
Well, I'll
what we
just
would now
rephrase
call
the
mean.
question. Why do you put your medals on your left breast?
I will ask
Something for the
someone
judicial
who-
assistant to find out by 4:30.
I have no idea what
All
is
the
the
pupils.
answer. It's a
But,
very
but it is almost universal, isn't it?
absolutely. Yeah.
Buttonholes are all on the left, aren't they? Buttonholes.
Buttonholes are always on the left.
Medals.
I am currently involved in a case concerning football kit.
Saying.
Football kit,
Okay.
where actually it's on the right,
Okay.
because there are other things on the left. But I suspect that's the only reason it's on the right rather than the left.
But if the club badge is on the left, presumably the marketing logo is on the right and stuff like that. Anyway.
Yeah, that's probably right, my lord. I can't now remember.
The danger
what
of this
it is on
subject
the
is you're
left.
going to get us diverting to all sorts of queries like the laws, and we need to get on.
Yes.
So what do you want us to look at 92?
Yes.
92 at 92.
Yes. Just read to yourselves. This is the judge doing the history of the brand, the HPC brand, and in 92 it's the origin. The idea that the phraseology, which has been, as far as I'm aware, used throughout the life of this brand as its reasons and justifications, it's in all their catalogues, it's prominently marketed. The idea that the image is not designed to capture the excitement of sport with membership of an exclusive social club. That it's not giving the public that message as its primary indicator, in my respectful submission, is one that, apart from being contrary to common sense, does not lie in the mouths of the claimant who asserts that this is how his brand originated and how it's presented, to say that's not how it works. This is what he's been trying to do for 30 years in marketing. He hasn't changed his game plan. If it works, then presumably it works. Anyway, the bottom line is the distinctiveness of the mark should be taken into account by the court in the assessment of infringement, in the same way whether distinctiveness is inherent or acquired. And the appellant's proposition that you have to show infringement and infringement hasn't been policed cannot possibly be right.
I noticed that nobody has cited any case law on prefixes and suffixes, which is another common instance.
Castellani will take us there.
Oh, right, okay, good.
Lord Justice Kitchen's statement in Interflora is a clear statement. The relative distinctiveness of mark is relevant however it arises, and it is relevant whenever one is considering the scope of protection to which a mark is entitled. The core issue in this case is whether the court should, when evaluating whether a sign is likely to cause confusion with a registered trademark, take into account the effect on the distinctive character of the registered mark of the use by third parties in the same market of signs containing elements which are the same as or similar to those found in the competing mark and sign.
So, as I understand it, you defend the judge's approach because it's relevant to distinct character.
Yep.
What about the question of context? Do you say that's an alternative route to the same conclusion,
No.
or do you say it's simply a different issue?
It's a different issue. The context issue is where the prima facie conclusion is there's confusing similarity, and the question is, does the context remove it? That is not the question in this case. The question in this case is, what are the expectations of the average consumer? And I say, both as a matter of common sense and as a matter of legal definition, the average consumer being someone who is reasonably observant and reasonably well informed, and reasonably circumspect, is someone who has basic knowledge of the market in which the goods are sold. If the consumer does not have that knowledge, then they are not reasonably well informed. They're coming in blind, if I may put it like that. And my learned friend's attempt to say that my argument is circular.
Well, on that question, what can you cite any authority in the context of trademarks as distinct from passing off that says that the average consumer is someone who knows what's commonly available in the market?
Well, I have you, my lord, in passing off, I know, but you said...
I said trademarks, not passing.
I know you did, and I know why you did. The concept of the average consumer, as your lordships are well aware, is derived from consumer protection law in European law. Good spring. And it is, if you read those cases, and I'm just trying to remember, Good Spring and Hyder is, I think, yes, it's extensively quoted in Interflora. Yes, page 452 of the authorities, tab 8, 117 at the bottom. There is an introduction to the quotation of Good Spring and Hyder. And that's all about what a consumer would expect things on goods to mean. In other words, if you look at the extract, starting at paragraph 30 of the Good Spring and Hyder judgment from CJU, the question is whether the description, trademark or promotional text is misleading. So they were starting with cases that included trademarks as well as product descriptions, trade descriptions. And in 31, they set out the test. In order to determine whether the description, trademark or promotional description statement in question was liable to mislead the purchaser, the court took into account the presumed expectations of an average consumer who is reasonably well informed and reasonably observant and circumspect. So the origin of the test, the benchmark, and you go on, you'll see examples in 34. Does a description of a car as new mislead because the car is pre-registered even though it's never been driven? And only if it could be established the decision to buy was made in ignorance of the fact that the lower price was matched by a smaller number of accessories. Sorry, that's the second point. There are two different ways that it could be relevant. The first was, would that have deterred a significant number of consumers if they'd known? The second one, lower prices with lesser accessories, only misleading if the question was if the decision to buy was made in ignorance of that fact. And at 37, they summarise the answer. The National Court must take into account the presumed expectations, which the statement or description.
That's the origin of this concept, is it? Average consumer, reasonably informed.
I believe Good Spring and Hyder is the earliest reference anyone has ever found to average consumer.
And that is then extended over into this jurisdiction.
Yes, well, as you will see, they mention trademarks as one of the things to which it could apply.
Yes.
So right at the beginning, it was applied to trademarks. I'll get on my hobby horse just very quickly. I have long thought that the word average has caused more problems than it's solved. Typical would be a much better word.
Well, average is a technical meaning.
Average in the sense of typical. And it is, there's no dispute between us, it's a broad church, but it does not include people who are either wholly or unduly ignorant of the market in which they're operating. And that must be the case from the extract from Berkshire in relation to what the mark or designation applied to the goods means in the mind of the average consumer. Now, as I understand it, there is no challenge to the trial judge's finding of fact that a device of a polo player swinging a polo mallet mounted on a polo pony is commonly used by purveyors of casual clothing which are polo themed, branded in a polo themed way. We say that, as a matter of pure common sense, consumers who are familiar with the relevant market will have an awareness of the nature of the branding used on the goods in question, something that's inevitable from exposure to the marketing of the goods. Consumers who are familiar with the market will know when marks have common themes or concepts underlying them and are frequently used. The example I thought might be more familiar to members of the court was German street shirt makers, who often have the names of the two founding members, Jeeves and Hawkes, Thresher
and Bull and Asser.
Hawes and Curtis, Harvey and Hudson, Thresher and Glennie, which now includes the late lamented Stud and Millington, and of course the legal outfitters in Chancery Lane, Eden Ravenscroft. So that pattern is immediately familiar to all members of the court. And you can, I hope you can see from what I'm saying that that kind of stimulus on the consumer's mind is exactly what you'd expect of the reasonably well-informed consumer. Now, apply precisely the same reasoning to people buying leisure clothing who are familiar with sports clothing of various different kinds. They see sports players wearing it. Polo is a hugely aspirational thing. It is played by royalty, it is played by the very wealthy. Unsurprisingly, when you consider what you need to have in order to be able to play polo. You need several polo ponies just to play a complete match. It's incredibly popular. Ralph Lauren was the first person to realise this. He's made an enormous market out of it. And with the greatest respect to the parties before the court, they're all following his lead, as are many other people. The judge did his analysis of the evidence of what's on the market at 191 to 202 of the judgment. And I don't understand my learned friend actually to try and criticise what he said. What he tried to do to you, before you this morning, was to suggest that none of this mattered because the big ones, Ralph Lauren and US Polo, look different from the ones he complains about. I hope it's immediately obvious to you from what I've shown you that is just flat contrary to the evidence. They complain about everything. And if you look at the Greenwich judgment, you'll see the way the judge summarised it. In that case, sorry, I've now lost my note. Paragraph. Oh, sorry, I've completely lost it. I'll have to look it up. Yes, tab 13 of the authorities, page 742. Entirely consistently with what I say in this case, the judge summarised the claimant's position as explained by the defendants in the middle of the page, just above the quotation. The defendants put the point as follows in their written opening submissions. The claimants object to all the signs. Their position appears to be that any branding with a polo player on a horse infringes, however many horses in whichever way they are facing. The claimants consider their exclusive monopoly to extend to parties who imitate the appearance, spirit and style of the brand. That's undoubtedly the case. In the Santa Monica case, it ultimately ended up in Lifestyle Equities and Arnold in the Supreme Court recently. They sued Santa Monica on different logos that included 1, 2 and 3 horses and succeeded. We respectfully say wrongly, but then the evidence came out rather differently in that case. And it is not consistent with the way the claimants have approached their complaints about horse and rider logos to suggest that they distinguish between those that are too close to them and those that are further away. With the exception of the ones they can't prevent, like Ralph Lauren, they object to everything that they can find. And at the trial there was a schedule of successful trademark oppositions which ran to many, many pages and had many, many other organisations, polo branding, listed in it. I can't, top of my head, remember who they all were now, but there were dozens of them. And they all have different pictures of polo players mounted on horses. So I say that the average consumer is someone who is reasonably well informed. My learned friend's attempt to suggest that it is a circular argument ignores the legal principle. Someone who is ignorant of the market is not reasonably well informed. And when he says that you have to look at those who know essentially of him and him only, because they are the persons to whom his mark is most distinctive, he is postulating that the average consumer extends to someone who is ignorant of the market. That cannot be right. There is a very good reason why the law requires the average consumer to be reasonably well informed. If it did not, the assessment of confusing similarity would be conducted in a vacuum, which bears no resemblance to reality. That cannot be the appropriate approach. The law of trademarks is concerned to protect traders and consumers in the real world, not in some idealised platonic marketplace, lacking the background to which real consumers are exposed in real life. Fourth, it is commonplace for marks in particular fields of commerce to have thematic or conceptual similarities. Sometimes they arise from a reference to a particular characteristic of the goods in issue, and the Castellani case demonstrates that in relation to wine, where the similarity arises from the fact that many wines are produced by houses called Chateau, Schloss, Castel, or some similar epithet meaning castle in another language. Consumers of wine are aware of this and recognise the theme when they see it. When it's used in the branding of wine, they know they can't rely on the Chateau part of the name or the Castel part of the name. You have to look at the rest of it. And then finally I come to the passing off test. There is a reference, which I'll just give you for your note, paragraph 78 of Planet Art, which quotes Mr. Justice Arnold as he then was, saying that in relation to passing off, the relevant consumers are those who are reasonably familiar with the nature of goods on the relevant market. And that principle has been set out in many places by judges in passing off cases. And coming back to my Lord Justice Arnold's point, if that is the case for one passing off, one would expect the same to apply in relation to comparison of trademarks. The key difference between the two causes of action lies not in the evaluation of the distinctive character of the mark in question, but in relation to the extent to which a defendant can rely on the use of his material, surrounding material, to dispel confusion which would otherwise arise. The answer is yes in passing off cases and no in trademark cases. Therefore, we respectfully submit that what the public is accustomed to in the marketplace is necessarily relevant to their perception of the similarities and differences between competing brands. It is frankly a matter of common sense that the way the public approaches what they see will be conditioned by what they are accustomed to. And I go back to the origin of the law, the average consumer's reasonable expectations. That's just me putting in different words the principle that's been laid down by the Court of Justice. The problem usually, as I've already said, it usually arises in relation to questions about descriptiveness when applied to a mark is applied to particular goods or services. And the arguments that the appellants advance include that the allegedly confusing matter in the parties' competing branding on the respondent's case, seeking to evoke the sport of polo rather than act as an indicator of origin, is not a description. My learned friend said it today. The goods are not used to play polo. And bear in mind that, of course, the classic polo shirt is modelled on the shirts worn by polo players. That's where the name comes from. But the appellants therefore say that because it's not descriptive of a characteristic of goods, it's not something to be taken into account. We submit the appellants are wrong. The impact of a mark or components of it on consumers' perceptions matters, whatever it is, when assessing the distinctive character of a mark. It arises, other than in the case of descriptiveness, relatively infrequently. When it does, either directly or as part of the analysis of the legal principles relevant to the issue for decision, in a particular case, the authorities are, in our submission, uniformly in favour of the respondent's position. The public's experience of what is on the market is to be taken into consideration in determining whether confusion is likely. Can I start with Authorities tab 23, the Court of First Instance in 0. That will definitely be in the third volume because it's the last but one. Now, I will tell you, I struggled to find cases in which the point has been expressly mentioned and tapped the collective consciousness of my chambers, which is quite extensive. And I was surprised by how little I was able to find. But what I found is consistent with my position and inconsistent with the appellant's position. So, 0 was a case in which the marks, as you will see if you go to tab 23, page 967, the mark was 0RH+, and there were lots of arguments about whether the public would recognise RH+ as a blood group indication of rhesus plus, and what word 0 would mean. But the key point for our consideration is that one of the arguments that was advanced was that the public was accustomed to seeing the word 0 in marks, and therefore it had limited distinctiveness. And you'll pick that up at page 977 and 72. Paragraph 72, the applicant's argument that many community trademarks and international registration contain the word 0, different forms and combinations, which diminishes the distinctive character of that word, must be rejected as unfounded. It must be held the applicant has not submitted any evidence that community trademarks containing the word 0, it says word, but it should say word, had genuinely been used. As regards the results of the research submitted by the applicant, according to which 93 community trademarks are made up of or include the word zero, point out the opposition decision found in that regard no indications how many such trademarks were effectively used. Applicant didn't dispute that finding, but nonetheless reverted to the issue of that evidence. It must be found that the mere fact that a number of trademarks relating to the goods at issue contain the word zero is not enough to establish the distinctive character of that element has been weakened because of its frequent use in the field concerned. It must follow that the court would have reached the opposite conclusion if it had been so shown.
So this is the familiar point. The state of the register is no evidence of use in the market.
Yes, but the corollary is use in the marketplace extensively. Assume it had been use in the marketplace rather than the state of the register which had been established. It would have weakened the distinctive character of the element zero. And that is precisely the point that I'm making. The next case I want to look at is a decision of Mr. Purvis, QC as he then was, sitting as the appointed person, in Hyalu, which is at tab 14 of the authorities. I think.
End of our second bundle.
The end of your second bundle, beginning of my third. Now this is a descriptiveness case, because whether or not I'm an average consumer, I immediately recognised Hyalu as being short for hyaluronic acid, largely because I used eye drops with hyaluronic acid in them. But if you pick it up at page 758, paragraph 3, the appointed person describes what the mark is. 2 words, Hyalu followed by biotic, second of which is clearly descriptive in biologically derived material. He then goes on to say that the opponent's case was that Yalu was confusingly similar, likely to cause confusion, looks compelling, but then he summarises that the dispute was whether Hyalu was in fact going to be recognised by the public as referring to hyaluronic acid. He summarises the point at 6. If it had no natural meaning to the average consumer, one can well imagine they might think it was connected to the brand Yalu, given the similarity. However, if the average consumer can be assumed to understand the word Hyalu is a common abbreviation for hyaluronic acid, or at least that it is used in trade to indicate a specific active ingredient, then there would be no reason for them to assume it is an indicator of brand origin. He then rejects the hearing officer's approach because she took the view that if you pick it up at...
Do we need to go through this and it's quite a lot here.
Pick it up.
Sidelined.
Yes.
Where do we get to the meeting?
I sidelined it so you can get the context.
Thank you.
The meat is on page 761 at 12.2.
Thank you.
You probably should read 12.1 as well, because he's summarising what the evidence is. And he says the difference in this case between it and zero is that the number of marks on the register, when you know what the meaning of hyaluronic acid is, indicates that that is the way it is used. You therefore do not need the extra evidence. There are lots and lots of goods on the market to reach the conclusion that it is in fact a reference to hyaluronic acid. And for that purpose, it may be legitimate to consider the sheer number of marks on the register. But again, he essentially assumes, as correct, in my respectful submission correctly, that if the public are used to seeing the word used in trademarks, it is of a low distinctive character, because they're accustomed to seeing it in many different marks. And the third case is where the point occurs directly. Authorities tab 21, Castellani. The point is set out, summarised in head note 8 at page 924. Consumer is so often exposed to the words castello, castel, chateau, schloss or castle. In this context, he must examine the suffix attached to it very carefully. And the final letters are different, castel, arni and uca. The discussion of the applicant's argument is at paragraphs 18 to 22. In particular, paragraph 22, where the applicant disputes the Board of Appeal's assertion the attention of the consumer will focus on the prefix, points out the idea of a castle is very common in the wine sector, states that in the territory concerned there are a number of registered trademarks containing prefixes, castel, castle, castle, castel and chateau. Consumers identify a wine by means of the suffix, devoid of distinctive character. Prefix is devoid of distinctive. Follows according to the applicant. The respective suffixes must be regarded as distinctive and dominant components. And paragraph 24, the applicant considers the prefix castel has little capacity to distinguish, so the average consumer is reasonably well informed. And this reads over to my point about what is reasonably well informed. A consumer who knows what's on the market in general terms. Not necessarily the case that two wines with trademarks beginning castel come from the same undertaking. And then the court's assessment of that at 54 to 61. So going over to page 933, and in particular paragraph 58. The use of the word meaning castle, a word meaning castle, is common in the wine sector. Germany is the fourth biggest world market in terms of wine consumption, although a large share of that market is covered by German wines. The predominant share consists of imports. Germany's main suppliers of wine are Italy, France and Spain. Consequently, the German consumer is accustomed to seeing a large number of trademarks for wine whose name begins with Schloss, Castello, Chateau, Castel or Castle. When purchasing wine from a specialist shop, a supermarket or a hypermarket, when choosing a wine from a wine list in a restaurant, he will therefore attach less significance to the prefix and closely examine the suffix. So that is direct authority in my respectful submission, that to which consumers are accustomed feeds into the average consumer's reasonable expectations and should be taken into account in assessing the distinctiveness of a mark. Now, the decision in Levi Strauss and Casucci. As I've said, it is said by the appellants to establish that diminished distinctiveness is irrelevant unless it satisfies two conditions: that what is present in the marketplace infringes, and that the infringement has not been policed, with the result, the effect of the competing marks has been to destroy the distinctiveness of the registered mark, that it should be removed from the register. Can I just, as an aside, point out that when my learned friend said he doesn't accept that the third-party goods that the judge has summarised in paragraphs 191 to 202 don't infringe, I think that may be the first time I've heard that said. I'm not going to go to the wall on that, but it came as something of a surprise to me. But secondly, let's assume that actually some or all of those goods are infringing. The consequence of that, they haven't sued them. The consequence is they've tolerated them. They have allowed them to be on the market. If they allow them to be on the market, It defies common sense, and it is unfair to allow them to turn around and say, what we have allowed to remain on the market should not be taken into account in assessing the relative distinctiveness of our branding when compared with other branding. Because that would allow them, just as the Court of Justice said an infringer could take advantage of his own activity by swamping the market, that would allow the claimants essentially completely to cherry pick and sue person A, whose mark looked virtually identical to person B, while tolerating person B and saying person A's is confusingly similar, but I'm not going to object to person B. It's completely unfair and wrong for that sort of result to be promoted by the law. It is virtually, it's certainly a common theme in trademark law that a trademark owner has to be vigilant. Indeed, that is the underlying theme of the Levi case when you read both the Advocate General's opinion and the judgment of the court. And a trademark owner who is not vigilant, it does not get full protection of the law. He chooses to tolerate, he has to accept the consequence that his mark, whether invalidated because it has become devoid of distinctiveness, or simply circumscribed because it has become, there are elements of it that have become common, does not extend to prevent the use of such matters.
So he has to sue everybody, does he?
Well, he wants to preserve the distinctiveness of his mark. He has to sue everybody he says infringes. Otherwise, it ceases to be distinctive. Now, bear in mind two things, which are, I started by saying trademark cases are very fact-specific. This is where I'm about to say fact-specificness matters. A mark may be a unitary mark, a single element, or it may be a composite mark. And the consequences of lack of vigilance or lesser vigilance may be different depending upon whether what is not objected to is the whole mark or just a component of a composite mark. So in the Levi, Strauss and Kosici case, the mark had a single element. It was just curved stitching in the shape of a seagull's wings, the mouette. Lots of other manufacturers of jeans adopted similar stitching. The consequence was that the precise shape of the stitching on the pockets of jeans ceased to be an indicator of origin. Now, there are no other elements to the mark, so the mark became generic, completely lost its distinctiveness, and should be revoked because it lacks distinctive character in limine. But with a composite mark, there is immediately, obviously, the possibility of an intervening position. A mark has two elements, only one of which is used by third parties. It is only the taking of that element on its own that is going to be an objection, because it is that element which has lost its distinctiveness. And that's this case. In fact, it's not quite this case because, of course, the claimants weren't the first in the market. There were others already there. Santa Barbara, Ralph Lauren, and in the US Polo Association. So they started with a relatively limited distinctiveness. They've tolerated Santa Barbara, they've tolerated Ralph Lauren, they have to. They tolerate the US Polo Association. They cannot complain that other marks which use common components are confusingly similar to theirs, because the public must have become accustomed to being able to distinguish between them. And that is emphasised by the fact that these marks on both sides include admittedly distinct and different names. The verbal element by which the average
Yeah.
consumer is most likely to remember them. So the proposition that simply because we've got a figurative element of a polo player mounted on a horse, and it's not the same as theirs, coupled with our name, gives rise to confusing similarity, is one that should be viewed with considerable caution in those circumstances. And when you find that where the goods are on the market side by side for years, there is no evidence of actual confusion at all, the proposition that the marks are confusingly similar is one that should be regarded as deeply inherently improbable.
Yes. Now, what other authorities do you wish to refer to?
Right, I want to go to Levi Strauss and Kasuchi.
Yes.
It's not about this point. The appellant's argument is a classic example of false logic derived from treating the minor premise as the major, what Lord Diplock pithily describes as the logical fallacy of the undistributed middle.
Of the what? Logical fallacy of the...
The logical fallacy of the undistributed middle. Most people call it treating the minor premise as the major. It's the classic, all sunburned men are handsome and therefore all handsome men are sunburned. The second does not follow from the first. Just because the two conditions in Levi Strauss lead to the conclusion the mark cannot be enforced against an alleged infringer, does not lead to the conclusion those are the only circumstances in which limited or diminished distinctiveness is relevant to the question of confusing
All right.
similarity.
Now, are we going to the authority or the Advocate General?
I want to go first to the authority,
Tab 19.
tab 19, and as necessary to the Advocate General.
Yes.
Now, remember the question, if you pick it up at 26 on page 910.
You're dropping your voice slightly, Mr.
I'm sorry.
Silverleaf.
I beg your pardon. If you pick it up at 26 on page 910,
Thank you.
the question,
Fourth question.
whether it is appropriate to order cessation of the use of the sign in question if the trademark has lost its distinctive character, wholly or in part, after that sign has begun to be used, and that loss is due wholly or in part to an act or omission of the proprietor of that mark. Now, that is the question which determines the answer. They were asking a very limited question. And they
So
get...
the passage that we were looking at, all this is relevant to the question in 26. Is that your point?
Yes.
Yeah.
Well, there were two questions. The time of assessment, which was the first and second questions, which are earlier in the judgment, and what you do if a mark has lost its distinctive character
Due to the actions or omissions of the proprietor.
in those particular
Yes.
circumstances. So they answered that question. They did not answer the broader question of, are the activities of third parties in the marketplace relevant to the assessment of the extent of distinctive character? They were looking at a very limited issue. And bear in mind that although they said that whether or not this infringement is to be assessed at the outset of the defendant's activities, they also said, if you go to paragraph 37, if the consequence of the third parties' acts in the market is that the mark has lost its distinctiveness, the remedy ceases. So they recognised that you could only have a remedy as long as the mark remained distinctive. Now, this is a very extreme case. It is a case where the entirety of the mark's distinctiveness had gone because of the acts of third parties in the marketplace. And not a case where, looking at the acts of third parties, you could see that the penumbra of protection was relatively limited, either in relation to the whole mark or in relation to particular components.
Was that because of the nature of the mark?
Well, that's because
Because it was a stitching.
It's a single piece, it's a unitary mark, what I call a unitary mark, as a single element, the shape of the stitching. But my principal point is they were answering a very limited question in a very restricted context. And you cannot draw from that the broader conclusion that the acts of third parties on the marketplace are never relevant to the assessment of distinctive character. Indeed, the conclusion they reached on that limited question is, in my respectful submission, consistent with the opposite conclusion. The acts of third parties are relevant, because in that limited circumstance, the mark fell to be revoked and no further relief was justified.
Can you illustrate that by a citation from the authority?
Paragraph 37. It's a very extreme case, but it is actually an application of the general principle that the activities of third parties are relevant to the assessment of distinctive character.
Well, 37 leads to that conclusion, does it?
Yes, because they say it's not appropriate to order cessation of the use of the sign if it's been established that the mark has lost its distinctive character and the mark is liable to be revoked. That's the extreme end of reduced distinctive character. You've got none left, no mark. But what you can't draw from this case is a proposition that until you get to that point, the activities of third parties are irrelevant. They weren't asked that question, they didn't answer that question, and the way that they answered the question they were asked is entirely consistent with there being general regard had to the effect of the activities of third party in the marketplace on the reasonable expectations of the average consumer, whether that limits the penumbra of protection by reducing the distinctiveness of the mark or an element of it, or completely eliminates the protection given by the mark because the mark has ceased to be distinctive. I hope that's sufficiently clear. The law of trademarks is notoriously difficult to get your head around.
Yes.
I've been doing it for over 40 years and I still struggle.
I suppose that's reassuring to somebody.
May say more about
Not sure it is, though. So what was there another point you wanted to take from Levi
That is
Strauss?
my answer to their primary case relying on Levi Strauss.
So was there another
I just want to
point
see
in
whether there's
Levi
anything
Strauss
else.
you wanted to rely on?
Yes. They point out that the protection of a trademark is conditional upon the vigilance by the proprietor in opposing the use of signs by other operators. That's in paragraph 30.
Right. So let's just
So
go
they,
there.
so it is important and it is relevant whether whether the proprietor tolerates the use or objects to it.
Right, that's the point you made earlier. Yeah.
Whether the signs which reduce the scope of protection are present in the marketplace before or only after registration of the mark in question, assuming it has some distinctive character, cannot affect the analysis. If those signs do not infringe, then they don't prevent the registration, if present in the market before the date. All they do is confine its scope. The same is true if they enter the market after registration. So the extreme case in Levi Strauss is simply an example of the broader principle that the activities of third parties are relevant when considering the presumed expectations of the average consumer. Now, the other point I would make is as a matter of reality, if a mark has lost its distinctiveness in its entirety as a result of the activities of third parties, That can only have happened because the proprietor has failed to prevent infringements. They could not have had that effect without infringing. See paragraph 34 of
Yeah.
Strauss. There is no need for a separate statutory provision to deal with registrations which remain valid, but because of the state of the marketplace and the act of third parties, have only a limited penumbra in which confusion is likely to occur. Validity is not in issue, only the scope of protection. That is, how similar a sign has to be in order to infringe. That is something which can only be addressed as a matter of fact on evidence as to the public's expectations and acclimatisation. The statute addresses this in the requirement there be a likelihood of confusion on the part of the public, and the authorities address it by saying that the relevant public is the average consumer who is reasonably well informed and reasonably observant. Contrary to the appellant's arguments, the reasoning in Levi Strauss is consistent with the wider proposition. What is done by third parties in the marketplace is relevant. Indeed, properly understood, the decision is inconsistent with the proposition being advanced by the appellants as to the relevance of the activities of third parties, in my respectful submission, because it is simply an example of the broader proposition. Now, I'd just like very briefly to look at some of the other cases.
Yes.
Jack Wills, which my learned friend
Yes.
said he was dealing with because it was cited against him. In fact, it's in paragraph 31 of his skeleton, which is why we
Tab
did.
5.
It said in 31.3 of their skeleton that it wasn't said in Jack Wills that third-party use after the date of registration could have reduced the registered mark's inherent distinctive character. Leaving aside the fact that if the point wasn't raised, it cannot have been determined, the argument is wrong. It is trite law that a mark can acquire enhanced distinctive character by use. It must follow that the opposite can occur. As a result of the public's habituation to and consequent recognition of other similar marks in the market, the ability of the mark to distinguish itself from those marks becomes reduced. That is necessarily so because the public learns that it has to look at the points of difference between the known similar marks in order to be able to distinguish between them. See Castellani. If that did not happen, the marks wouldn't distinguish. This has nothing to do with inherent distinctive character and everything to do with distinctiveness and use. Indeed, if you look at 31.3 of the skeleton, the remainder of the argument set out there is a recognition of that principle. Because in that case, as my Lord Justice Arnold will no doubt recall, other bird logos were put forward. And as Lord Justice Nugee said earlier this morning, the difference in that case was that the similarities between the Jack Wills logo and the House of Fraser logo were far greater than the similarities between those two logos and anything else in the market. And Mr. Justice Arnold, as he then was, consequently held that there was an inherent high degree of distinctiveness in that combination of common features. It's an entirely unsurprising decision on the facts. Those two were very different from the others. That is precisely the impact. The public's recognition that third-party marks were much more different from competing marks and the competing marks from each other emphasised the differences and increased the perception of similarity between the competing marks. That is precisely the impact of third-party activity, which we would say is relevant. The only difference is on the facts of Jack Wills. The result of the impact is the opposite of what it would be if the third-party marks and the competing marks were equally similar. It is the same principle applied to different facts. Unsurprisingly, the outcome is different. I would say also the implication in the argument that the issue of distinctiveness resulting from the use by third parties of similar logos was not considered is wrong. The court recognised in paragraph 98, look at that, the final sentence of 98 in Jack Wills, which is tab 5, which will be volume 1 in everybody's volume.
Paragraph 98.
Paragraph 98.
Page 283. This is my law, isn't it? So your proposition is
It's the last sentence of paragraph 19.
that the implication, what is the appellant's implication,
Yes.
that the issue of distinctiveness resulting from the use by third parties was not considered in this case is wrong.
Sorry, that reference is obvious rubbish. Is it paragraph 87? Oh, hang on, am I in the wrong case? No, I'm in the right case.
Probably earlier, isn't it?
Paragraph 87 is definitely sidelined. I'm just trying to remember why.
Paragraph 98 makes the point that consumers will have become accustomed to distinguishing between different bird logos on clothing.
So that is a good reference. I just haven't marked it properly in my copy. Yes. Except the consumers will become accustomed to distinguishing between different bird logos. They're not accustomed to distinguish between logos consisting of silhouettes, anthropomorphic birds wearing top hats, and other accessories of an English gentleman. So what they are accustomed to distinguishing between is relevant, and the point was also considered at 87, because that's where the judge held that the anthropomorphic aspect in the final sentence is, and in particular the fact that the bird is equipped with accessories associated with an English gentleman, is the distinguishing characteristic, and therefore what serves to set those marks apart from what else is available in the marketplace. I would also say that the appellant's reliance on total and U view is misplaced. Total and U view is tab 11 of the authorities, which I think will be in volume 2. Volume B. If you look at paragraphs 91 to 93, you will see that the starting point, the judge summarises the relevant material in 91 and 92. You'll see issue 6 is there a likelihood of confusion. At about a third to halfway down, 92, he says, I've found that there is a high degree of similarity between the two marks in issue. Close identity or close similarity between the goods and services makes it inherently probable that there may exist a likelihood of confusion. Adopting the perspective of the average consumer and so on, I consider that there is a likelihood of confusion. And at the end of 93, having described the circumstances in which the goods are supplied, in these circumstances, given the overall close similarity, I consider there is a strong likelihood of confusion. So the starting point for the argument is that the parties' respective marks were so similar that there was a strong likelihood of confusion on the part of the public. And as appears from the next paragraph, the purpose for which the context was relied on was to say that nevertheless there would be no confusion.
Yes.
That is a different question. The marks are confusingly similar. Does the context dispel that? The question in this case is not that question. It is, given the context, are the marks confusingly similar at all? The trial judge has found otherwise. The remaining analysis in total and U view is therefore beside the point. Planet Art and Photo Box, which is the next tab, and is the other case relied upon by the appellants, also does not support their position. Paragraph 4 on page 638, the judge discussed out the generally applicable approach. This case was all about the words free prints, which is obviously highly descriptive. And in those circumstances, what the judge says is, you can see why the first trader and the second trader may be aggrieved. You get a reasonable degree of latitude to the second trader. 2 reasons for this: broad policy to avoid monopolisation. The other is because consumers are to be taken to be sufficiently astute to be able to discriminate between the use of the term as a brand and the use of the same or a similar term in descriptive sense because of its immediate context. In such cases, the similarity of the term in question means that the likelihood of confusion as to trade origin is low, because the term in question in the defendant's branding does not denote trade origin at all. While that is a characterisation of the general legal principle, as I outline in greater detail below, there is no general answer in law to that question, and resolution requires close attention to the specific facts, which is why I always caution against arguing from one to the other. If you go to 21, Judge points out that verbal elements may be more important than visual ones, and that is a significant factor, even more so where the verbal elements are, as here, admittedly distinct and are the obvious indicator of trade origin to the public. And this is another case where the impugned use was prima facie confusing, and the question is whether the context took it out of infringement, see 24 and 25, which is what you were shown this morning.
Yes.
Particularly 24. Considering infringement is not appropriate to look so broadly at the context, the use which was prima facie infringing was nonetheless to be regarded as non-infringing because other separate acts of the defendant had countered actual deception. That again is the different question, which is not the question which arises in this case. Now, I've got a long section in my note on the average consumer taken from Interflora and Marks and Spencer's. I've already said to you that it's at 170. Sorry?
I said you've already been over that.
I don't want to go through it in any detail. It speaks for itself. Perception of the... I'll just pick up particular points. At 120, the court quotes...
Sorry, where are we now?
This is just for your note. You don't.
So these are references to Interflora?
It's to Interflora.
Yes.
Paragraph 120, the court quotes the approval from the CJU decision in Lloyd and explains that it means that the perception of marks in the mind of the average consumer is decisive, and goes on to point out this is the perception of a reasonably well-informed consumer. And at 122, the court reiterates this is the presumed expectations of the benchmark average consumer which are to be taken into account. And 129, you'll see the summary set of the conclusions set out in full. Note in particular the final sentence, setting out the test as being driven by the presumed expectations of the average consumer. That passage is quoted with approval in Enterprise and Europe Car at 135, Authorities tab 7, page 353. We consequently say that it is clear that the reasonably well-informed average consumer's expectations of what matters. It is axiomatic those expectations will be driven by the notional person's knowledge of the market and the goods. To suggest otherwise makes no sense. The nature of the average consumer becomes devoid of content if you take that approach. Coexistence agreements.
Yes.
The appellants criticise the judge's approach. We say that his analysis of the agreements and his conclusions in relation to them are entirely unobjectionable and correct. The judge was entirely right that the Omega decision doesn't establish a general proposition about the irrelevance of coexistence agreements, and entirely right that they are, by and large, a good indicator of what sensible commercial operators think can be tolerated. The Omega case concerned a dispute between two parties who had entered into a coexistence agreement in relation to the market dispute. In such circumstances, the agreement either regulates the issue in dispute or it does not. If it does, then the provisions of the agreement determine the dispute. It provides the answer because that is what it is for. If it does not regulate the issue in dispute, then it must be irrelevant. The agreement does not answer the question, and the question has to accordingly to be answered according to the legal rules and principles applicable to without recourse to the agreement. Put simply, an agreement between the parties to the dispute can only be relevant if it purports to deal with the issue in dispute. The agreement in that case, the court held, did not seek to address the question of confusing similarity. It didn't say that either party could not oppose the other party's applications. Therefore, the court said that in those circumstances, it was irrelevant in the present case. All the court was saying was that unless the agreement was directed to the question which was before the court, which it was not, then it was irrelevant to the determination of the question. The trial judge was therefore correct to reject the appellant's argument. The Omega case establishes a general principle that coexistence agreements are irrelevant. The decision says nothing about the relevance of coexistence agreements between the parties to the litigation and third parties who also use similar marks to that in issue, or between third parties who use similar marks. Such agreements are a perfectly sound indicator, as the judge held, of what the parties to them consider to be acceptable in the marketplace to preserve their respective trademark rights. The court is therefore perfectly entitled to, and should, in our respectful submission, take them into account when considering whether the marks in dispute before it are confusingly similar. Moreover, where there is a coexistence agreement, it can mean only one of two things. Either the parties have agreed that if regulated in the way provided for, there is no likelihood of confusion, or they have agreed that any confusion there is to be tolerated. In either case, they cannot complain. If they have agreed that confusion is to be tolerated, they cannot complain if it occurs unless the agreement specifically provides otherwise, in which case the provisions of the agreement determine the outcome. More importantly, for present purposes, if this is precisely the kind of conduct on the part of a trademark proprietor which was contemplated by the court in Levi and Casucci as leading to the conclusion that the proprietor should be disentitled to enforce his registration. He has agreed to certain conduct and therefore cannot complain that it infringes his rights. I would therefore submit that Levi is yet a further indicator that, taking into account the terms of coexistence agreements between the proprietor and third parties, it is relevant in assessing the distinctive character of a proprietor's trademark and its consequent scope of protection. My lords, that is all I wanted to say, unless you have any questions.
Thank you very much, Mr. Silverleaf. Yes, Mr. Edinburgh.
My lords, if I might, I was going to take it very quickly. But I do have a number of points to make.
No.
The first of which is,
No rush.
it was said that we have sued in this particular case with respect to not just sign 3, but also with respect to signs 1 and 4. But sign 4, defendants, first, second and third defendants said that they did not use sign 4. That's why I didn't focus upon that. You'll find that in the defence and counterclaim of the first 3 defendants, paragraph 24, subparagraph 2, which is on page 222 behind tab 9. With respect to sign 1, Again, I did not focus upon that, and that is because they've stopped using that because of the Ralph Lauren agreement. You'll find that in the supplementary bundle behind the tab 3 and sub-tab E, page 229. So as a matter of commercial reality, sign 3 is the matter before your lordships. Next, it was said that in the Greenwich case, complaint was made about a whole range of different marks. That's absolutely true, but that case was lost by Lifestyle Equities, and they've moved on. Third point was that they tolerate Santa Barbara. That's a very much more complicated situation. The agreement that you'll find behind tab 3 in the supplementary bundle dates from 1997, and you'll see in the judgment at paragraph 88, which is behind tab 61 on page 91, that, oh, sorry, tab 6.
Tabs, yeah, yes.
My
I
apologies.
don't think we got to tab 61.
Not yet.
There's a lot more authorities you're going to be citing in reply.
Yes, no. My apologies for that, sorry.
Tab 6.
Tab 6, page 91. It's the last sentence of paragraph 88 in the judgment. This is where the trial judge is talking about the evidence of Mr. Haddad. Mr. Haddad said...
Hang on, we're in the judgment.
In the judgment, yes, my lord.
Sorry, I was distracted by Lord Justice Burse and Victoria's Secret, so that's not an authority which we've cited.
No.
Yeah. Okay, so in the judgment.
I was just going to read it out, my lord, because it's only a sentence.
Okay.
This is where the judge is talking about Mr. Haddad's evidence, and Mr. Haddad, and this is the quote, said they were currently in litigation with Santa Barbara in various venues around the world, including the UK. So, to make the general proposition that they've tolerated Santa Barbara is not in accordance with that evidence. There was a general point then that there was no dispute with respect to various horse and rider elements being common in this particular trade. In my submission, that's just too broad a submission. Because yes, we accept that Ralph Lauren is common and also USPA, but it's not a proposition that we accept with respect to the side-on logos. There was a point here about Santa Monica, how the claimants were successful in that case against 3 different logos, the first of which had 1 horse, but the second of which had 2 horses. That is true, but the 2-horse logo was just the first logo with also its mirror image. So it wasn't really a 2-horse logo, it was just the first logo doubled up, so to speak. And the 3-horse logo, against which there was also success in Santa Monica, was only upon the section 10.3 ground, not the section 10.2 ground, which gives you wider scope of protection in any event. You were taken to the Castell case in the authorities bundle, tab 21. This was the one with respect to the castles.
Wines.
Exactly so. In my submission, this is a completely different sort of case because there are literally, and I make this by way of submission, hundreds of wines in every wine shop which have that sort of marking, chateau this, chateau that, or what have you. It's a completely different case here where the judge said that Ralph Lauren and USPA dwarfed all other users of horse rider logos. The 3rd and 4th in the market were probably the defendants and the claimants in different jurisdictions, but everybody else fell below that. So this is a completely different situation with respect to side-on horse and rider logos. My Lord Justice Baker made the point about the fact does the claimant have to sue everybody? Because
Otherwise, you're tolerant, and therefore you're
exactly so.
therefore it's your defect that of course
Yes.
caused the problem.
In my submission, the answer to that question is no, you do not have to sue everybody. What you have to do is you have to sue those that are effectively destroying and undermining your distinctiveness. And that takes into account, in essence, their market presence. Because if there's a very, very small party out there that is just not worth the candle suing, then you shouldn't be held in default by not suing them. And this must be taken in the context that, of course, the defendants advanced an anti-suit injunction application because the claimants were so vigilant, according to them, in trying to pursue the major defaulters, according to the claimants. So they can't have it both ways in my submission. They said, basically, the claimants are vigilant because they do sue people who they take commercial objection to, but they haven't sued everybody. That is true. They haven't sued everybody. But we say that there must be commercial reasons for that. I can't give you any proper facts, but that's my submission. That brings me to the next point, which was, of course, it can be held against a registered proprietor if through their acts or inactivity there is a loss of distinctive character. But if that loss of distinctive character is not due to their lack of activity or whatever, then it can't be held against the registered proprietor, because that's the only way in which a mark can be revoked, is through the acts or inactivity of the registered proprietor. But if there's a separate reason for loss of distinctiveness, then the revocation action doesn't work in those cases. You were taken to paragraph 21 of Planet Art. The last sentence of that does read that you should not ignore important visual elements. So yes, the word element is important in a combined mark, but the visual element should not be ignored. And then briefly with respect to the coexistence agreements, when you read the Omega judgment and you marry that up with what was said before your Lordship just now, it's in my submission that coexistence agreement in the Omega case did regulate the dispute between the parties, because there was an issue of whether or not Omega SA, that's the Swiss watch people, could apply for such a mark. And then it was also possible, but not decided, that Omega Engineering, the American people, could or could not object to that. That goes to the very essence of the dispute between the parties. And yet it must be in the General Court, didn't say that it was relevant. There's a small point here, and that is coexistence agreements are settled between the parties, and the position of the parties and their view with respect to whether or not there's an existence of the likelihood of confusion or it can be tolerated must be borne in mind that the parties, and in particular the lawyers who settle those agreements, can't be equated with the average consumer. It's a technical point. And then finally in this case, there's a nuance that, yes, the parties might agree between themselves by some sort of private arrangement that the existence of the likelihood of confusion can either be minimized or tolerated, but that can commonly be done by some sort of acknowledgement or recognition that in the real marketplace they operate in different sectors, and so therefore they're actually not commercially in conflict, even though in reality, if you looked at the analysis, they would be in conflict. So there might be many other reasons why a commercial coexistence agreement can come into existence that actually defies the trademark analysis of the matter as opposed to a commercial settlement of the matter. My lords, might I just check whether those behind me have anything?
Thank you very much, Mr. Edinburgh. What we're going to do now is we're going to rise for 10 minutes to take stock, and then we'll come back and we'll let you know where we've got to and whether we're going to need to hear the argument on the respondent's notice amendment. Thank you very much.
All right, security. Just to let you know, the live stream will carry on running, but it's very short here now. But do go back to business as normal.
Right, okay.
They said 10 minutes, so please be back.
We're on
for
camera.
less than 10 minutes. Yes. It's not finished yet. You can leave your trolley on the side there if you want. They're coming back in 10 minutes.
10 minutes? Sure.
Yeah, so it might be finished after that.
Okay,
Might.
thank you very much.
This must be the most boring television experience ever. Sitting there watching the
I don't know
whole.
how many people are watching it. Does that mean?
But is there not, when you watch it, when you actually stream it, it tells you how many people are watching, doesn't
No, I'm not sure.
it? Right. Pretty confident there are at least 2 people watching. But I know those. And I suspect there may be a third, but I know her as well. Harriet? Julie? Yeah, she usually drops anything into the classes. Yeah, but it's too you go traffic, I wonder how useful the law of international air transport must be.
Council, are we all ready? Call rise if you're ready.
Well, we've decided that we're going to dismiss the appeal for reasons to be given in due course in a judgment which will be circulated in the usual way. We hope that we'll be able to hand down judgment this term, but we can't guarantee that that will be the case. When you get the draft judgment, the usual rule applies, that it's a draft intended for correction of typographical and minor factual errors, obviously not for re-arguing any of the issues. Please bear in mind that it's a confidential document, the draft judgment must not be circulated beyond those identified, and any circulation is a contempt of court, as you'll be warned about by the rubric at the top. We'd be grateful if you would agree an order that reflects our decision. If there are any ancillary issues that need to be resolved, we'll do that in writing on the basis of short written submissions. In view of our decision, it's not necessary to hear the application to amend the respondent's notice. So we're very grateful to you both for the way in which you've argued the case, and also grateful to those who sit behind you for all the hard work they've put in, and very grateful to you in particular for managing to complete this case in a day. Thank you very much.
Right.